Good morning. I am Manish Kumar from CMR Law College, Bangalore, and today I will be talking on Section 164 of CRPC. Section 164 of CRPC deals with the statement taken by the magistrate. Subsection 1 of this Act empowers the magistrate to record a person's in testimony or confession regardless of whether he has jurisdiction over the case. Subsection 6 will apply if he does not have such jurisdiction. The term statement refers to any statement made by a person who is not a witness and not a confession. Any Metropolitan Magistrate or Judicial Magistrate, for that matter, whether or not he has jurisdiction in the case, may record any confession or statement made to him in the course of an investigation under his chapter or under any other law in force at that time or any time thereafter before the inquiry begins. Grounds on which Section 164 of CRPC be challenged in High Court. A warning is mentioned in Section 164 Subsection 2. According to the statute, the magistrate must first inform the accused that he is not obliged to make a confession, and if he does, it may be used against him. This is a requirement for confession. This is requirement for confession recording. Another obligatory condition is that the magistrate must interrogate the accused to ensure that the confession was voluntary, so that he can issue the required certificate under paragraph 6C of this Act. The magistrate warned the accused that he was not obligated to make a confession, but he did not risk any question to ensure that the confession was voluntary. In Mahavir Singh versus State of Haryana, the court held that if magistrate fails to inform the accused that he is obliged to give a confession, and that if he does, the confession could be used against him, the confession cannot be condemned. Bar against police pressure. Subsection 3 ensures that a person who refuses to make a confession is not subject to police coercion when an accused has been in judicial custody for more than 2 days. Prior to providing a confession, it had been decided that time is adequate to remove the accused's fear and influence from the police, if any of the confession delivered voluntarily. The time between preliminary interrogation and confession recording does not have to exceed exactly 24 hours. It may be less, it may be more. Manner of recording. The confession must be documented in the manner prescribed by the Section 228 and signed by the person who made it, according to Subsection 4. Then the magistrate will write a memorandum at the bottom of the confession. The magistrate is unable to simply sign a printed directive that has been provided to him. This will be a violation of the rule in this section. The accused must sign confession in order for it to be valid. If it isn't, it won't be admissible in court. Thank you.